application and appeal in the matter of Campbell, a protected party who proceeds by his father and litigation friend Donald Campbell, and Advantage Insurance Company Limited.
Yes.
May it please you, my lord, and fellow lordships, I appear on behalf of the respondents in this matter, and my application is listed first. My learned friend, Mr. Ross of Queen's Counsel, appears on behalf of the appellant, and I am with Mr. Snarr, who's holding my duty. My lords, the application is to rely on the trial skeleton arguments, in particular the appellant's skeleton argument, and it is supported by the statement of Mr. Mike Pope.
Oh, sorry, I'm not aware. I was only half listening, so I thought you were going through the formal parts. This is an application which I failed to anticipate. Is it?
It's listed.
I'm sure it is. I'm sure it is. The fault is entirely mine, but I hadn't clocked it. What is the application for? Just don't do it formally. Just tell me roughly.
It's to rely on the trial skeleton arguments.
You rely on in what sense? You can refer to them anyway.
The trial skeleton arguments.
Yeah, why not?
Well, they should be part of the bundle, are they not?
They would. My learned friend did not agree to them being part of the bundle.
What does the practice direction provide on bundles?
The practice direction provides that there should be agreement. There wasn't agreement. If there isn't agreement, there has to be an.
So you want to rely on his skeleton?
Yes.
Well,
or refer to it?
I want to refer to it.
Is this worth having a row about?
No, it's not.
Well, why did you make a row about it in the first place then?
No, what we say that it's not relevant. That's all, my lord. But the position is that my learned friend's already sought to make some points about my skeleton in his appeal skeleton already. I'm going to be operating under huge time constraints to get through what I need to get through.
Seriously? This is a whole day case.
Yes, my lord, yes.
You're going to be operating under time constraints?
I think I might be, yes. I've got it.
Well, let's wait and see.
Yes.
Is this a big point, Mr. Ross? It doesn't sound like a big point.
It's not a big point. And I was going to suggest, my lord, a way through it, mainly. Let my learned friend start making his submissions, which he will be doing this afternoon. We've decided how we're going to split up our time. And if he feels a pressing need at that stage to raise it and refer to something in particular, it can be addressed by the court at that stage once you have an appreciation of what the point is. So I was proposing that
let's wait and see.
Exactly.
Right.
Thank you. Well,
Yes. Sorry, and I have been completely confused by this application. I've been calling people by the wrong names and everything. But right, off we go.
So I'm for the. My lord, as I said, I fear we've got some time constraints on our side, and so.
Well, I am genuinely surprised. We have read the papers. We know the facts.
Good.
Of course, you'll want to refer to the key facts, and the key evidence. But
Indeed.
I really, you think you're going to be?
No, what
more
I've
than
done
a
is what I was going to make the point was I've reduced my submissions to writing in the hope that that'll help speed things up and we can refer to them much more quickly. So I've got a speaking note. If I can hand that up to your lordships, and a friend will get a copy of it.
If you wish, we already have, I think,
Quite a long skeleton.
a skeleton argument which, although artfully the skeleton itself is 22 pages, the appendices take it over to 31. It doesn't help the court to have lots and lots of paper, and the rules say 25, and that doesn't mean 25 plus lots of appendices. However, we are where we are. Well, you're going to give us some more paper, are you?
If I could, it'll just.
Okay. If you
it's
think
what I'm going to submit to the court.
If you think it'll help, we'll of course see it.
I hope
Yep.
it does. I'm hopeful that it will.
I'm sure. I didn't know that.
Thank you.
Yeah. Okay, the problem with speaking notes is I never know whether to you're just read it out, are you? I mean, I don't know exactly how to use it in advocacy.
Yes, well, that's how I'm going to try and
Okay.
speed it up by referring to it, yes.
Okay.
So, my lord, this, as your lordships know, arises out of a concise body of uncontested direct evidence. We submit that's unlikely to recur. It's obviously a triple tragedy in this case. As the court knows, the defendant died as a result of his decision that night. His brother Aaron, who's the witness in this case, took his own life sometime thereafter. He had given witness statements to both sides. And obviously it's a tragedy for my client, who's now unable to confirm to the court what happened during the course of that evening, and to address the issue of his incapability of looking after his own safety, certainly after the time when he was removed from the club by the defendant driver and his brother. It's a tragedy for another reason, which is that but for the fact that the defendant and his brother decided to intervene and take the claimant off the bouncers who were removing him from the club, he would have not been in this car. The bouncers, we respectfully submit, would have either found him a taxi, as the trial judge postulated was likely, or an ambulance to the nearest A&E department so that he could be seen over. The reason why we respectfully submit these facts are unlikely to recur, I should mention.
Does it matter with
the defendant, the claimant's father is present in court at the back. I should have mentioned that at the outset. Yes.
Yeah. Do continue, but I mean, does it matter why the facts are unique?
Well,
The facts of every case are unique.
but the facts of this case are unique because the issue that arises in this case is one that seldom does arise. And the Australian cases that I'll take your lordship to at the end of the day have contemplated a scenario the same as this. And there is some important statements of principle by the Chief Justice McCrossan and also by Mr. Justice Lee, which address this very question, which is what happens when you're looking at foresight of risk.
Well, look, I'm sorry. When the judge intervenes, it's meant to speed things up, but it's probably slowing things down. I'll let you go on your own way.
The reason why this is important is because it's not the standard case of drinking in a public house or a club where there's been a pre-arrangement, or indeed where somebody has drunk within the public house together with the person who later becomes his driver. This is somebody who would not have gone with the driver but for the intervention of third parties, one of whom happened to be the driver. And he, the driver, placed him in the car. And that would be material on the question of foresight of risk, which is an essential ingredient of proof of the existence of contributory negligence. The reason we say they're unique is because there were no witnesses who can give evidence as to the events at the end of the night, so there's been no opportunity for questioning of them. And inevitably, the one witness that we do have, Aaron Brown, has not covered all aspects of the events of that night, and so there are gaps, there are lacuna in the evidence. Next, the fact that the claimant made no decision whether to be taken to the car. He was unable to walk on his own, was supported there by the defendant and Aaron, and placed in the car in an unconscious state. We say unconscious because the term he used was passed out. The fact that the other sole witness, Aaron Brown, knows nothing about the likely final 25 minutes before the defendant set off in the car, that is 25 minutes after Aaron Brown had departed to go back to the club. He says to look for jump leads. And the fact that even the defendant's brother was not expecting the defendant to drive away. He was coming back from the club expecting the car still to be there. The fact that no one knows when or how the claimant came to be in the rear seat, whether that was done with outside assistance from third parties or not, another unknown. and the fact that no one knows about the conditional state of awareness of the claimant at the time that the defendant chose to drive away. The fact that no one knows whether there was any attempt by the defendant to warn the claimant that he was going to drive off, or whether he asked the claimant for permission to drive him away. As we know, he was driving him away in an odd direction. It wasn't towards the claimant's home. It was in the direction of Oxford for a purpose nobody knows. And certainly his brother Aaron doesn't suggest that the car was going to go off in the direction of Oxford. So we say, notwithstanding the paucity and the gaps of the available evidence, defendants obviously raised this issue of contributory negligence. It appears to be common ground the obligation of proving contributory negligence lies on the defendant. I think that's established by the passage in Clark and Linsell at your appeal bundle, second appeal bundle at 493, and also by the case of Malone. There being no evidence which covers the final 25 minutes before the defendant chose to drive away from the place where his car had been parked, the conclusions as to what happened during that period, the claimant's physical condition and state of mind, whether he knew he was about to be driven away by the defendant, and whether he consented to that course of action, are all conclusions of inference alone, which the trial judge was minded to draw. Before coming to examine the evidence, it follows that this court, we submit, is as well placed as the trial judge was to determine the inferential conclusions which is proper to draw in this case, or not. The trial judge appears to have acknowledged as much when granting permission to appeal. I appeared below. I wasn't called upon by the trial judge when we sought permission to appeal. The body of case law in the first part of Appeal Bundle 1 confirms this court's entitlement. We would say it goes as far as a duty to consider the question of what are the proper inferences to draw from this uncontested body of evidence that was placed before the court. The cases will be obviously familiar to this court. They will concern this court's powers. And we have marked up to identify the way in which judges of high authority have articulated this course of powers of intervention on appeals such as this. The Lords, therein Appeal Bundle 1. I wasn't proposing to take your Lordships to them.
I don't think you need.
I thought you might not need it. But they're there for the court's convenience. So the submission is that this court is in as good a position as a trial judge to decide what are the safe and right inferences to draw as to what occurred during that likely 25-minute period after the brother left to return to the club and left the claimant sitting in the front seat of the car and before the defendant chose to drive away in the direction of Oxford, leaving his brother behind. There's a short chronology. I refer to it because I've drawn it up. Your Lordships have that.
Is that the same?
Yeah, I put that back.
I see.
It's a very short document, just giving you times, and you can see from that.
Well, we are very familiar with the,
Good, I'm glad.
with the facts. We really are.
So the table of Aaron's account as contained in his 3 witness statements, that was exhibited to the supplemental bundle, to my skeleton.
But again, we've looked at that.
Page 40.
There obviously are differences, and mostly on the question of whether there was a seatbelt in the early phase when he was in the front seat, whether the seatbelt was fastened. But on the material points, there isn't any real difference, is there?
Well, with respect, there isn't very much difference. What is important, however, in relation to that was that if you go to SB 42 at the bottom.
Do we need to?
Well, no, I'll read it out. He's got him, the brother has got the claimant in the front seat, upright in the seat, he's closed his eyes and has already almost passed out. They left him in the car to sleep it off, and he was asleep when they departed. He's mentioning that when they left him to sleep it off, it was only a short conversation with him getting back into the car. as he was in no fit state to talk, and by the time we closed the door, the claimant had passed.
This is all what you've set out in
Yeah.
para 13 of your speaking note.
Yeah.
Yeah.
So that's what I've tried to summarise there. You've got him passed out. This is not something which the trial judge refers to when he comes to the critical 25-minute section. He doesn't refer to that fact at that juncture.
But which fact does he not refer to?
That the fact that when Aaron last saw the claimant, that is before he departed for the second time from the car to go back to the club, that the claimant was passed out.
Yeah. Okay.
So I've tried to identify stages of drunkenness for the court very briefly. I think this will all be familiar to the court.
It's not familiar to me, but is it where does it come from?
Well, it comes from regular medical documents that are available generally from the NHS and places like that. So it's just indicating where, what stage this man was at. He's obviously toppling over stage at the very least. So we've got a legless and inability to walk phase, where the midbrain is affected, and we've got stupor, we've got jitteriness, we've got nauseous, we've got him paralytic and may involve a loss of consciousness. And that's the stage which we respectfully submit that this man was in.
When?
Well, when he was placed in the car,
Yeah,
and
that's what I
again, when he was last seen by Aaron, because Aaron has him still passed out when he departs.
So there's no evidence that his condition changed from that point.
Precisely.
Is that your point?
That is. It's consistent throughout that he's passed out, and that's after an hour of being left in the car upright in the front seat when he was passed out. And they come back and he's still passed out.
And then effectively, the judge's inference was that because of the fact that he was in the back seat, the fact that he was in the back seat must have, he inferred from that his condition changed. Is that putting it too simply?
Well, I don't know, because he didn't articulate that. And that's why I made the point that the judge, when reaching those conclusions...
Well, I can see from this speaking note, as I would expect, that you're shortly coming to an analysis of the judgment, so perhaps that's the point at which we should make those sorts of criticisms.
Yes. So there's some known unknowns which I've attached to the back and just tried to tabulate them again to assist the court. And I've got 14 of them. Oh, the judge's finding as to condition. Perhaps I should look at that first, my lord. That's again in a table form at the back if you're...
Well, it's up to you, but if we're going to go through the judgment, there's a risk we'll do everything twice, isn't there? I don't want to put you off doing it the way you want to do it, but I am anxious to avoid duplication, yes.
I understand, but I think this...
Whichever way you
The reason I'm trying to put this before the court is because respectfully submit that it encapsulates in quite neat order the issues that are most important.
Okay, whatever,
So-
however you want.
Thank you.
So we're looking at 13, are we?
So we're looking at the document that's got, looking at 15, my lord,
Okay.
of my speaking note, and referring to the trial judge's findings as to his condition. Findings as to the findings relevant to the claimant's condition is the appendix to the speaking note. So there's 3. There's no evidence of an earlier agreement. 4. There came a time where it was obvious that Clement was very drunk. 5. He was in the car for about an hour. sitting in the front seat, and the description is passed out. Claimant was passed out when he's placed in the front seat of the car, and when they got back to the car, the claimant was still asleep or passed out, paragraph 24. Claimant did not wake during the hour they were away drinking in the club. We go down to 17. Trial judge accepts that when Aaron left to go back to the club, the claimant was still, he says, asleep. I say the evidence of Aaron indicates that he was passed out. The reason why that may be important is because, of course, Aaron's account is that when he came back to the car, he got into the rear seat. It's a two-door car. Therefore, the driver's seat would have to be pulled forward. He would have got in the back seat. The car didn't start. The same process of exit would have had to be followed. And throughout that time, the claimant was in the front seat, passed out, and he did not react according to, well, put it this way, Aaron does not suggest that he reacted in any way during that period of time, and indeed he indicates that when he departed, he was still passed out. So coming back to paragraph 18 of this schedule, the claimant was unable to execute the necessary manoeuvres by himself.
And paragraph 18 of your speaking note?
No, paragraph 18 of this schedule that I'm looking at with the division.
Thank you.
Far more likely that the defendant assisted the claimant into the back seat because he was unable to do the necessary manoeuvres himself. The change of position was the defendant's idea. Next, we come to the bit that we challenge, the change of position.
So just hang on 1 second. You were saying about when you say this isn't cross-referred to the bundle.
This is
Para 17, the paragraph 12 of his third witness statement. Where do we find the third witness statement in the supplementary bundle? You probably know what's meant by the third. There were 3, but they're not called the first 1, 2, and 3. And
Is it
if you look in the schedule, it was most helpful if we go back to that table that I did of the evidence, my lord.
Next to your skeleton?
Next to my skeleton.
Yeah,
yes.
yeah.
well, if you want, but I would rather just be given the reference.
Is it the third chronologically, Mr.
It's
Ross?
the third chronologically, yes. That's right.
Tab 6.
So
It's the second one he did for the claimant. Yeah,
Yes,
okay, that's fine. Thank you very much. Just wanted to mark this up with the reference.
Yes.
Um,
And if you look at the table, we can see it very briefly at SB.
Speaking for myself, I always like to see the witness statement, not tables, but I use the table for pre-reading.
SB 42 and 43. The final column.
I'm just looking at paragraph 12 of his third witness statement, which is at page 22 in the supplementary bundle. Yes,
we
so
left
that's
Lime
all,
in the car.
that's all entirely about the time when he first left him there. And then what he says in para 14 when they came back was, Liam didn't wake while I was back at the car.
That's right, and then
Yep,
you have to go to the very end, paragraphs 19 and 20 of that same written statement. He was never in a fit state to put seatbelt on himself or to get himself into the car on his own. He needed.
That's obviously a reference to when they first put in.
And paragraph 20, as I've said, he had passed out before we left him to go back to the nightclub, and he was still passed out when he returned to the
Well,
car.
that's the key one rather than paragraph 12. Yeah, okay, I've got it. Thank you. It's very helpful.
Can I just check, all these were admitted under the hearsay provisions?
Yes, sir.
Yeah, as one would expect. Yeah.
So I think I'd got back to that list of relevant findings to the claimant's condition and his position in the car. We'd got to 22, trial judge unable to say why the defendant drove away in the direction from...
Do we have any maps with the nightclub, the respective home addresses?
My recollection is we did have...
I couldn't find it in the bundles.
Right.
But that may be my error.
No, I fear it's not your lordship's error. I fear there may not be the supplementary bundle.
Do you know the addresses? Have you got the rough where key places were?
Yes,
I haven't.
we did have. I can't immediately identify.
Well, perhaps that's another thing that can go in the supplementary bundle.
Yes, perhaps my lord.
The accident was at Northleach, wasn't it? Is that right?
That's right, on the A40.
There's a map showing the location of the accident as part of the police report. The nightclub was in Cheltenham.
Yeah.
The homes are in Gloucester.
Yes, but it's the addresses.
It's the addresses.
Yeah.
I do know that this was something that was before the court.
Well, were they the addresses local to Cheltenham? I suppose.
And the home would be around 15 minutes of direction.
About 15 minutes in the opposite direction, I'm told.
Opposite direction to the nightclub.
No, sorry, half an hour in the opposite direction from the accident.
It will really be helpful to know, Mr. Ross. Sorry.
So club to home would be about 15 minutes.
15 minutes.
Club to up.
It would be
Mr.
helpful
Ross,
to know
perhaps we-
precisely the village or town or roughly where they were. Were they
If there was a map below, the simplest thing is to
find
get it over lunchtime and
Indeed.
give it to us. Yeah.
Thank you. Um, 20 years. Well, I think the judge is accepting at 22 that the direction that they were travelling at any rate was away from the place where his home was. That's in paragraph 62. And then 23, claimant cannot have known how much more the defendant had drunk. That is, after he'd been placed in the car, there was no evidence. The claimant knew for how long he was left alone in the car. There was no evidence concerning the claimant's awareness of any behaviour exhibited by the defendant during the process of the claimant transferring from the front of the car to its rear. So if you go on to the next one, I've drawn up what I believe are a list of unknowns in this case, which is what I invite the court to concentrate on with respect. Did the claimant know he's been placed in the defendant's car despite his dreadful state? What happened the last 25 minutes before the defendant decided?
Sorry to interrupt, but just on that first one, because that's obviously relevant to your submissions on the law. Did he know he was being placed in the car despite his dreadful state? He was conscious in the sense that he was capable of moving his legs and assisting in that sense.
Well, it's supported he was capable of moving, but
Yeah.
the evidence from Aaron is that he couldn't stand up by himself.
No, I understand that. But if someone is in that state and has sufficient competence to realise that it's better to be sick out of the door than in the car, what do you say then that means in terms of the reasonable, prudent and competent man?
Well, it's the defendant's car that's the important factor, as opposed to a car,
Yeah.
because it's the defendant who's going to drive him away, and it's that linkage that's essential before you have the finding of contributory knowledge that you're accepting.
But once you've got to the state that he was in,
Yes.
for all the good reasons that he was happy and had the promotion, he must have realised he was then completely dependent on the brothers for the rest of his evening, especially when he's put in a car.
Dependent in what sense? Sorry.
Well, for getting home and all the rest of it. He's not been taken to accident emergency. He's not been reported to the police. He's not been put in a taxi.
That's right, he hasn't. But the question still remains, did he know where they were taking him?
Well, is that necessary? Anyway, I think Sorry, but I think let's. You're wanting to do this in a methodical way. These are all points that we'll have to come back to when we come to your submissions. At the moment, you're just taking us through the facts, which we.
Have I got this fact right? That on Aaron's evidence, after he was sick, he was still passed out.
Yes. He was left in the car, passed out in the front seat.
And so he was comatose, you say. The evidence says, Aaron said he was comatose after he'd been sick.
Yes.
Do you say that makes a difference to the relevance of the vomiting? My Lord's suggesting to you that the fact that he was able to be sick out of the car
Yes.
indicated that he wasn't comatose at that point.
Well, it's a reflex reaction in our respect for submission. Whatever state you're in, you try not to do it on yourself. Respect. So it's not a conscious action in that sense. If you're completely unconscious and you've got to the stage where you're flat out on the ground, then it may well be.
I'm sorry to ask. I'm very conscious from the father's point of view how difficult it is to talk about these matters. I'm sorry we've got to, Mr. Ross. But that the way you put it, it's an instinctive react. It's an instinctive act.
Just a reflex, yes. And more importantly, it's not just when he's in the front seat. Aaron comes back an hour later. Aaron gets into the back seat. Aaron gets out again. Aaron's evidence is that then he was still passed out. So the last evidence that there is of his state before the car's driven off, maybe 25 minutes later, is that he was passed out. And that's the evidence. And the evidence is for the defendant to adduce and to establish contributory negligence.
You're talking rather quietly. Can you?
Yeah.
Anyway, keep going, Mr. Ross. Are you wanting to take us through these 14 known unknowns?
Very, very, very briefly, because I think they are.
It's not enough for us to read them to ourselves. I'm only worried
Yes.
about time, Mr. If you're confident you'll finish by, there's a lot of law and stuff to get to,
There is.
and I think it is the whole point of writing this down. It's some of it we can read for ourselves. Isn't it?
Yes, it is.
Well, why don't we just read through this?
Thank you, Lord.
Yes. Yep.
So, my Lord, coming back to my speaking note, paragraph 17, the speculation and assumptions by the trial judge, so these are grounds 5 to 7, on what we submitted the errors into which he fell. How he got into the back seat is important, bearing on whether he was ever awake. Drove off immediately after he'd been placed in the back seat. I accept there's no specific finding to this effect, but we respectfully submit it's implicit in the learned judge's findings that entry into the rear seat also manifested his consent to being driven away. Certainly it's clear the trial judge did not address the question of the prospect of a significant delay before the defendant drove away. And if the trial judge had accepted that the defendant drove away at a later stage, he failed to consider that the claimant may have fallen into a drunken sleep yet again whilst on the back seat and before there was any intimation that the car was going to be driven off. The point being, he's put in the car. The suggestion is, oh, we must have known he was going to be driven away. He wasn't. For a whole hour, he was left in the car whilst they went back to the club to drink. The same thing happened the second time. They come back to the club, the car doesn't start, and he's still in a passed out state, according to Aaron, by the time they depart to get some jump leads. Some 25 minutes elapse or thereabouts, and Aaron comes back and the car's departed. Nobody knows what happened that 25 minutes. The last evidence is that he was passed out. Admittedly, he was in the front seat at that stage. But nobody knows how he got into the back seat at all. The whole prospect, the catalogue of possibilities arise. Did Aaron do it, did Dean do it by himself, manhandling the claimant into the back seat? Or did he have passers-by to help him to do that? There's every prospect that he called passers-by to help him get this man who was passed out or thereabouts into the back seat to help him say he'd drive away. Why did he do that? The judge suggests that the reason he did that was because Aaron was going to come back and Aaron was then going to get into the front passenger seat. That's why he was moved to the back. Who knows what it was? And if he's been put in the back seat for 25 minutes or so, we know what happened in the previous hour. He went back to sleep, passed out, according to Aaron. Why was he passed out again 25 minutes before the defendant suddenly decides to drive off? But the defendant made a sudden and unexpected decision is manifest from Aaron's own reaction. He wasn't expecting that. He was expecting to come back to the car and find it still there. It wasn't. So there's no suggestion. It came as much of a surprise to Aaron as it did to anybody else. So what I'm saying at 17.3 is the question has not been faced of what if the claimant had been sleeping on the rear seat for approximately 25 minutes before the decision was made to drive off. So the main errors by the trial judge, we respectfully submit are agreeing or not objecting to being placed in the rear seat is not implied consent to be driven away, still less by the defendant. We submit it's clear that the claimant's priority was to find somewhere to sleep, as he did in the front seat. So too he would in the rear seat. Especially it's not implied consent if you've been left passed out asleep on the rear seat for that period, 15 minutes to 25 minutes. And there's, as I've mentioned before, there's no reference in the judgment to the claimant being passed out when the defendant and Aaron left the car. When they returned and Aaron had left to collect the jump leads. The reason that there should have been is because in our respective submission it goes to the critical issue of the claimant's alleged agreement to being driven away by the defendant. So I've then gone through...
Let's ask you this, is it any part of your case that even if he even if you say he can't, even if he can be said to give an implied consent to being driven home, he didn't give implied consent to being driven in the other direction? Or is that a red herring?
No, that is a valid point as well, because it's to a destination unknown and for a purpose completely unknown. The oddity is, of course, that it's something which the claimant in that state obviously would have been of no use to the defendant at any other venue. So it's a complete mystery as to why he chose to drive away. It's suggestive of an impulse. And it's suggestive of the fact that there was no prior warning that it was going to happen. So it's not appropriate in our respectful submission to fix this claimant with contributory negligence.
I think
because contributory
he
negligence...
was either going home and got lost, or he was going on a journey for another reason.
For which we don't know, but it's in the opposite direction. That's the point. It's not close to.
That's right. For my part, I'd like to have precise geography. I'm sorry to bang on about that. It would be interesting to know what it was.
So I've then gone through the judgment, and I think I can deal with this very shortly.
Oh, this is the most important part, isn't it?
I'm going to deal with the early bit shortly.
Oh, I see. Okay, right.
Not all of it. So we've got to the table again within the body of the speaking note. The burden of proof. This is one of the issues we raised. We respectfully submit that the requirement appears to be forgotten when the trial judge got to the issue of his condition, where he deals with capacity. In any event, the outcome of the capacity inquiry is not, we respectfully submit, determinative of the question of whether the defendant has established contributory negligence. Because the question is not, did the claimant have capacity to make the decision to agree to be driven away, but of foreseeability of the risk of harm to himself.
You'll come into the law later, but I think you're going to have to persuade me at least of the bit you've got between the dashes there, because it's an objective test. The question is surely whether a sober person, assuming that they were awake at all, you've obviously got a big point there,
Yes,
but if they're awake,
yes.
and broadly speaking know what's going on in the sense they know they're being about to be driven off, a sober person would certainly have realised, wouldn't they, that Dean was too drunk to be driving safely, and there was a risk that something would happen.
Well, it's not a pure objective test, and I think it's
right,
quite clear from all the number of instances.
Then I think we've got to get to. I'm just flagging up that is a point that at the moment I don't accept. No doubt when you show me all the authorities, you may persuade me, but it's very important what exactly is objective, and at what point the fact that he's very drunk kicks in.
That's right. Now, if before he gets drunk and he knows he's going to be taken off in a car, that's one.
Well, that's a whole different.
But that's not
case.
this case. This case was, according to the trial, there's no prearranged agreement. That's not how he was going to go home. But he happens to, when he is very drunk, he is taken hold of. He's taken away from the bouncers. That's the tragedy in this case. Taken away from the bouncers and taken to this car. He's then left for an hour. It's not moving. he's not been taken.
Well, you've made
these
points.
Yeah. Well, the point is that he became hopelessly drunk before ever there was a risk that he might be taken away by the defendant. And that's where the foreseeability of risk is the critical ingredient of this equation in our respectful submission.
You criticise the judge in relation to capacity, but you very fairly flag up in your own skeleton that you had, or someone had raised it in the particulars of claim.
Yeah,
do we have the particulars of claim?
Yes, yes, you do. No, it's in the. Forgive me, I'll find it.
It's page 128 in the court.
Thank you. I certainly read them before, but I couldn't remember where they are. I can't find them.
It is.
Yeah, thank you.
The fall from grace is that when I was referring to his, as I would now prefer to call it, his capabilities, I suggested that he lacked, I should have said he lacked the capability to consent, but, and he did not consent. But I did use the word capacity. I accept that. I meant it in the non-legal sense. I meant it in the more general usage sense. But it was something...
it was your particulars of claim anyway.
Yeah, it was. Absolutely.
We'd better just see the paragraph if you wouldn't mind.
Yes, it starts at 128, Lord. Paragraph 8, I'm dealing with material facts.
Yes, but just where's the bit where you refer to capacity?
Page 130, subparagraph 12.
Thank you very much, Mr. Kennedy.
Unable to reach a capacitous or informed decision as to whether he wished to be driven away.
Yeah. Okay, so it's actually pleaded, not as in any way relevant to contributory negligence, which it wouldn't be for you to plead at this, to that sort of matter for the reply. Yes. But it's pleaded as a particular of negligence against the defendant.
That's right.
Yes. Do we have we don't have the defence in the reply, do we?
You do have a defence. The defence is, oddly, the passage before.
Yes, it's rather odd. It's been put in that way around. So I missed it. Yeah. Okay. Well, But that's fine. So, but where's the pleading contributory negligence?
The plea of contributory negligence is in
117.
Thank you. Paragraph 12. And there wasn't a reply pleading to that?
no.
You'd slightly led with the point anyway, haven't you?
Anyway, there we are. Thank you. Right. This was all jumping off the first of your boxes
Yes.
in the analysis of the judgment, which I've now temporarily. So I have it now. Yep. No, I have it now. Yep. Right.
So I'm making the point there, I won't repeat the foreseeability of the risk to harm given his then conditional state.
Yes.
And the timing is critical
Yes.
in our respective submission. So I think we can whisk over the page. The evidence and findings of fact was the judge's subheading. I'm making the point simply that his condition, the evidence is just conditioned solely within the witness statement of Aaron Brown. That's why we submit this court's in as good a position as the trial judge.
Well, you've made that
draw
point already, yes.
Inferences. The judge is accepting at 17. There came a time when he was very drunk. 18, the point that I made previously, the judge does not mention that Aaron said he passed out at the critical time when he came back to the car for a second time. The collision, the judge finds it's probable the defendant has fallen asleep at the wheel and says it's not necessary to make a finding of fact on that issue. So reasonably foreseeable risk, again, is an issue. Is it just drink or is it the actual cause of the accident that gives rise to
Is that
damage
none of this
to
matters,
the
is it? I mean, this isn't an issue before us. Am I missing something? It's perfectly clear that the defendant drove negligently.
Yeah.
And surely, surely it was. If he had been sober,
Yeah.
he would have realised that he was driving with someone very drunk, and therefore it's reasonably foreseeable there might be an accident. That's the whole basis of this body of the law, isn't it? I'm just not quite clear what point you're making here.
I'm merely raising the prospect that the risk that eventuated, if this be right, is a slightly different one from the one which the judge was proceeding.
But it was all of a type. You get into a car with a drunk driver, you take the risk you're going to have a terrible accident, unfortunately, according to the law. I mean, you can't say, well, just because he swerved over the other side of the road rather than hit on the same side of the road, it wasn't foreseeable. No. So this point takes us nowhere, does it?
I accept that.
Can't we go to paragraph 32?
Yes.
Sorry, isn't that where we get to the crunch in the judgment?
Yes. So how do you come to be on the road? So the trial judge accepts that he went back to the club. He was still asleep on the front passenger seat. I'm pointing out in two places where Aaron's evidence is that he was passed out.
Why does that matter? I mean,
Well, because over the page I say there's a significant difference when it comes to cognition if he was passed out. And it was for the defendant to prove his state at that stage. So the defendant proved it.
Passed out. You're quite right to use, which is the word used in the evidence. This is a lay person. All it means is he was unconscious. He might have been asleep. Aaron is not likely to distinguish between different sorts of not being conscious.
Yes, but if he's not conscious, well then...
Fine, okay, but I just wasn't sure whether you were attaching some significance to the exact phrase passed out. All Aaron means is that, clearly meant was that he wasn't conscious.
Well,
But that could be asleep, could be a drunken sleep. I don't quite know what passed out means more than that, doesn't it?
well, maybe, but the point is that he wasn't conscious, he wasn't in a
Yep,
position
okay.
to make a decision in relation to it.
Yep, no,
If he's in that state.
See that, of course.
That's-
Everything depends, obviously, on whether he woke up or was woken up in order to do the manoeuvre into the back seat. That's the judge's reasoning.
Yeah,
Yeah,
and,
okay.
and we submit what happened thereafter is absolutely critical, and that's the thing the judge didn't address. What happened to him after he got into the back seat? Because the only basis upon which the judge concludes that there was
It's not
consent
necessarily
because he
right.
moved into the back seat.
Let us suppose, and you may say the evidence doesn't go this far, but I just want to pinpoint this particular point. Suppose he is woken up, asked by Dean to go in the back seat and helped to do so if he needed to be helped. And a reasonable person at that point would have appreciated this was because Dean wanted to drive him, right? And a reasonable person would have appreciated that Dean was drunk and that it was unsafe to be driven by him. The fact that he then does it, gets back into the back seat, and then goes to sleep, and maybe Dean doesn't drive off for another 10 minutes until he goes bored of waiting for Aaron, doesn't really matter whether he's gone to sleep afterwards. The important thing is whether he was awake and conscious and knew what Dean was intending to do, or should have known what Dean was intending to do, during the period that he was awake. Isn't that a correct analysis?
No, with respect, that's not so, because the assumption that's been made by your lordship in that respect is that the moving into the back seat was for the purpose of ultimately being driven
No, I wasn't making an assumption. I was saying if that is proved or reasonably inferred, I'm just getting at your point that nobody's considered what happened if he went back to sleep as soon as he got in the back seat. The point I'm pointing out is that the crucial issue is what he should have understood during the period that he was temporarily awake. Whether he went back to sleep afterwards and was asleep at the moment that Dean actually turned a key is beside the point.
Not beside the point with respect to the Lord, because the reason he was placed in the car for an hour beforehand was not to drive away, it was to let him sleep.
No, but if during that time he'd been told, I'm going to drive you away now, I'm just waiting for Aaron to come back with the jump leads.
Yes.
Assume it was as stark as that. The fact that he then went to sleep again wouldn't help you.
Maybe not, but there's no evidence to that effect.
No, I understand that, but I'm trying to see what the point really is. I'm just trying to isolate the fact that him going back to sleep afterwards is irrelevant. The important point is what we should infer about what he should have understood during the time he was awake. Is that correct?
Well, I don't accept that he was awake when he's
No, I know,
out of
but
the front seat
that's a
into the
different
back.
point.
Yeah.
I just want to focus on the points that matter and not on the points that don't matter. Well, I put it...
It does matter, but it's not the point the Lord's putting to. Your point is, the Lord's putting to a different point.
Yeah, could
Well,
your lordship,
I'm
could
a
your
bit
lordship
strict
try
on
and...
that. I think if I'll say it one more time and then I'll stop. If all the things that need to be proved are proved in respect to the time when he's being moved from the front seat to the back,
Yes,
if all those things are proved,
yes.
the fact that he then goes back to sleep and is asleep at the moment that Dean actually turns the key and drives off doesn't add anything.
Yes, I do accept that. I do
That's
accept
helpful.
that.
Okay.
But, yeah. Because it's
You're not
merely a
making a
delay,
big
it's
concession
merely
by
a
making
delay
that. I
in the
just want to be
fulfilment of what was the agreement between them.
Yeah.
Yes, I accept that.
Good.
But that... Your lordship's got my point about that.
I have got your point entirely, yes.
Yes.
I mean, being in the back seat, being put into the back seat of the car, ought that to have led him, if he was awake at all, to realise that he was being driven off?
With respect, no, because he's been left for an hour sleeping in the front seat with no one driving away. Why wouldn't he be in the back seat for an hour?
Well, why put someone in
Asleep
the back
in-
seat?
Well, so far as the claimant was concerned, it could have been a bed, it could have been a bench, it could have been he's put in a taxi, it could have been any of those things. No evidence to suggest that he knew he's being put at that stage into Dean's car.
No,
Is my point.
but speaking for myself...
The reason this case is interesting is because there's no evidence.
Oh,
and
yeah.
and what
Yeah,
the judge has been trying to do, in our respectful submission, is to fit a theory to these facts. And the evidence doesn't support that with respect.
But I think what we're coming to, and I don't think you're giving anything up by accepting this, everything turns on what happened and what he should either understood or should have understood, depending exactly how you say the law, during the brief episode when he moves or is moved from the front seat to the back seat. Everything turns on that because just being put in the car an hour previously doesn't take you anywhere. But if during that episode things happened that should have made him realise that Dean was going to drive off in the car, then you have a problem. And if that can't be established, you don't have a problem.
But the car at this stage couldn't be driven away. That's the other factor the court has to have regard to. That's why Aaron departed.
Well, it couldn't at that point, but the whole point
But
was
if he's
he was going to get it started.
But if he went back to sleep before the car was started,
But
then
why does that make a difference? Suppose,
Because the
again,
car is
just
not
test
moving.
it this way, Mr. Ross. Suppose he'd said, and he had taken in, sorry, Liam, we want to go home, but the wretched car won't start. Aaron said he'd go and get some jump leads. Can you go in the back seat because it'll be easier then, and then we'll go when we got it started. Now, suppose that had been said, which I know you say it wasn't said. The fact that he'd gone back to sleep in the back seat's irrelevant, isn't it?
Sorry, my lord, I was looking for the passage and I'm going to take your
Oh,
lordship too.
okay, well,
Could
there's a
you-
risk
could
we'll
you
go
put the
around in
point to me-
circles.
Could you put the point to me again? I'll endeavour to.
Well, I'm afraid I just thought you were reverting to the point I thought you'd agreed was irrelevant, that the fact that he goes back to sleep before he knows whether the jump leads have been got or not, or whether the car in the end is able to be started without them.
But on the
That's surely irrelevant. He thought the intention was, if he thought the intention was to drive him home when they could get the car started, that would be enough for the defendant's point of view. And it didn't matter whether he actually knew how or whether they would get the car started.
assuming he was awake when that conversation took place. Yes.
Yeah.
Assuming.
Yeah,
There's no evidence of any such.
No, well, that's your best and key point.
So, my lord, I think the lordship's driving me to the essence of the case that I'm trying to put over. Can we go to the case of McPherson in Appeal Bundle 2?
Well, we're coming back to the judge's judgment, are we, at some point?
Yeah, well, we can do it any.
No, I'll do it as long as we are coming back at some point, so we need to understand.
We've
how
only
the
got
judge
paragraph
reasons.
Well, let's carry on with the
Whichever
the
way you
judgment,
want to
and
do
then
it.
I'll take you straight to that case once I've
Okay.
analysed the judgment.
Yep.
We've got to 32, have we? Now we're on 35.
I've made the point at 32, why I say it's significant. 35, unable to execute the manoeuvre into the back seat by himself, and therefore he's been assisted. We respectfully submit the trial judges assumed that was done by D alone, but it's an unknown. We don't know whether people passing by assisted in that process, but they help literally just dump him in the back seat. We don't
And getting into the back seat would have involved pushing the whole seat forward or just tipping it?
Tipping
backrest,
down the back.
tipping the backrest
Yeah.
Tipping
forward.
the back of the front seat forward and
Back of the right forward and then into the back.
assisting him into the back.
Well, yes, we've assumed assisted. The judge has assumed assisted. He could have been thrown there by defendant and whoever he chose
He
to.
could have got him back unassisted or been literally
Yeah,
bundled in.
yes,
Bundled in.
especially passers-by assisted in that process. We don't know.
So that's a finding of fact that you criticise.
Yes, we submitted. It's an assumption that it was done by.
Impermissible inference.
There's no evidence on it at all.
Well, the evidence is he was in the front seat, and by the time the accident happened, he was in the back seat.
That is
Everything between the two has to be inferred.
on the
How he
basis-
got from one to the other has to be inferred. He did get from one to the other. That's clear.
You don't know when he got to the back seat.
Except that it was
He could-
after
he could have-
Aaron left for the second
It
time.
could have happened on the way to Northleach. You could have stopped the car at Underhill. It's completely,
that's why-
it's completely unknown. I think
come
I'm
back-
helping you on this. when I say
That's
it's
my
unknown.
whole case. This is unique.
Yeah.
And the reason it's unique is because there's so many lacuna in the evidence. Now, that may be unfortunate for the defendant who's trying to prove contributory negligence, but it's the fact of this case, and which is why I say, with respect, these are very unique facts which are unlikely to recur. And the test that you're going to apply has to recognise that fact and has to recognise the foreseeability element that has to be established in relation to finding of contributory negligence. And the Australian case addresses this pretty directly.
Right, but good.
Paragraph 41, the trial judge addresses the question of cognition and physical coordination capabilities of the defendant, but he doesn't undertake the same process for the claimant. 42, it's assumed the claimant has moved into the rear acting alone. Made the point, no evidence. 43, trial judge has also assumed that allowing himself to be manoeuvred into the rear seat and lain down, the claimant knew what the defendant was doing so in order to drive him away. And we query whether the trial judge was accepting the defendant was asleep on the rear seat. There was no evidence of what, if anything, the claimant was told by the defendant. Trial judge's conclusion was in fact contradicted by the placement of the claimant in the front seat. That was not done so he could be driven away. No evidence the claimant knew that the defendant was to be the driver or that he was about to depart. 44, the last sentence reveals an error on the trial judge's part in our respectful submission because he assumes the car was going to be driven away then and driven away by the defendant. Aaron's evidence was to the contrary with the start. 53, finds helpfully for us that the claimant had passed out when placed in the front seat of the car. 55, he doesn't refer to the evidence of Aaron that he was passed out the second time around.
Can I just go back to 43? Just show me where. Could you show us where in 43 you say that the judge made that assumption?
Well, I say it's inferred, in fairness to him, because he doesn't say. He doesn't. It's the converse. He doesn't mention a period of delay or the possibility of a period of delay before the car was driven off. So 43 is
it's the first sentence of 43. TJ has also assumed that by allowing himself to be moved into the rear seat, he knew that he was doing so in order to drive him away. Where does it say that in 43?
No.
43 is about a quite different point. 43 is about where in the back seat he was. It starts, where was the claimant positioned in the rear of the car?
I simply can't see the assumption that you've attributed to 43.
Well, maybe I'm attributing it to the whole of it, rather than, I think, in fairness to the trial judge, it's not mentioned in 43, but he's dealing with the manoeuvring into the back seat in 43.
This is a very unfair way of looking at the judgment. The judge is dealing with different points at different stages of the judgment. You're just making the same points again and again and again and hooking them on to bits of the judgment to which they don't really apply. All these points are perfectly good points that you're making, but
I accept your Lordship's point in relation to the point I made in paragraph 43. I stand to be corrected.
Please.
But I have been insufficiently clear. When he's dealing with the moving of the position, I've gone on to the rest of his judgment in saying what I've said. So,
sorry, I think my Lord asked you about, you'd moved on to 55. Yeah.
Trial judge doesn't refer to the evidence that he was passed out. See the table of evidence, which I've taken the Lordship's to. Referred to this aspect of Aaron's evidence because it goes directly to the question of the claimant's state. Trial judge poses 4 questions in paragraph 56.
55.
Correct. And raises the issue of consent being driven away and consent to be driven away by the defendant. When we get to paragraph 57...
I'm sorry, again, forgive me.
Forgive me, Lord, yes?
55. TJ does not refer to the evidence found that C was passed out when he returned to the car an hour later.
He said he was
55
asleep.
says, when Dean now returned to the car, the claimant had been asleep for a time, probably for around an hour or so. I don't...
No, the point is he's referring to sleep rather than...
What's the distinction between sleep and passed out?
Well, one is when, as regards sleep, it can be that you've decided to go to sleep. Whereas if you're passed out, you've passed out because you're not in control of your
He's
faculties.
fallen asleep as a result of being drunk. I mean, you can't pick the judge up on tiny phrases like this. Clearly he means what you mean by passed out. The question is whether you can be whether he was roused at some point.
I'm sorry, you were on 57 now, were you?
I was 57. Yes.
Well, this gets us on to the Mental Capacity Act, which no doubt you're going to come on to.
So I'm submitting in relation to paragraph 57, the question still remains, did he agree to being driven away and driven away by the defendant? And that doesn't begin to address or answer the questions posed in paragraph 55.2 judgment. And 55.4, allowing a change of position. 58, judge set for himself 4 questions in paragraph 55, which sees that. When he comes to 58 and 56 and 57, concludes he could answer all of them in relation to C's decision to consent being moved to the rear seat, even though there's no evidence as to how that was done, whether any objections or matters of that sort. The last evidence before the court, mentioned to your lordship before, claimant could have been moved then, having been temporarily roused from that passed out condition. We submit that trial judges conflated 2 separate issues and treated them as one: capacity to know and agree to being moved to the rear seat, and capacity to know and agree to being driven away. In fact,
well, isn't the key point, perhaps in your whole appeal, is the second sentence of 58. It was impermissible from the judge to move from the finding that he must have known he's being moved from front to back, to concluding that it was only consistent with him agreeing to remain in the car while it was driven away.
One doesn't follow on from because it depends on his condition at each.
Well, that's the law, whether it is a reasonable, prudent, competent person making that, given the facts. Because if you were put in the back of the car at that time without the drinking that had gone beforehand, the natural inference to be drawn was that at some stage you were going to be driven off, especially if someone's going to get jump leads.
But there's no voluntary element in relation to this, where he's being put into the back seat when he's in that condition.
Well, is that right?
Well, that's our submission, Lord.
Yeah.
That the evidence doesn't suggest that it was a voluntary decision. They've taken him. I mean, he was going to be taken out by the bouncers. He's taken to this car by then. He's put in the car. They accept he couldn't have done it himself. They've left him there for an hour. They've come back. At some stage, he's been moved into the rear seat. None of that is indicative of somebody who is in control of his faculties or in control of his senses or being making a choice in relation to this. There's no voluntariness in relation to that. What is it's being done to him, not with him.
Well, that's I mean, the findings are really at 57, aren't they?
Yes, and we say that so 57. It only answers the first question in 55.
Yes.
The information in relation to the decision is simple. It involved the claimant getting out of the front and getting into the back.
I mean, the judge is saying really this, isn't he? The only reason for moving from the front seat of a 2-door car to the back seat is if the car is going to be driven.
And by the defendant, yes.
Who else would drive it?
Well, right, but in this case, by the defendant. And that's
well, it's assuming he knew which car he's being put in as well, doesn't it?
Well, it's the combination of factors. He was in the front seat to start off with.
Of a car, yes.
He's there. He then gets into the back seat in the way we've described.
somehow or another.
Not by opening it's not a 4-door car. It's a 2-door car. So the reason for that, the judge is saying, is that somebody else wanted to get in the front seat. So,
But
why would somebody else get in the front seat? Because the car was being driven
this
away.
presupposes that the claimant was
Well,
able to rationalise all
well,
this. And that was the
absolutely.
point.
Well, if he was able to rationalise it,
Pardon?
if he was able to rationalise it,
Yeah.
And the judge
I mean, his
he was.
condition, yes. So if he's mildly drunk, yes, if he's mildly drunk and he knows what's going on and so on, then that might be a starting point for Malone Friend's suggestion of contributory negligence. But that's not the evidence in this case. You have to have regard to the claimant's state at
all
the
right.
time.
Well, then if we go back to the middle,
his movement into the back.
if we go back to the middle sentence of 58, which I suggest to you was the key point of the case, do you accept that if the judge was right or entitled to find that he must have known he was moving from front to back, the judge was also entitled to find that was only consistent with agreeing to drive being driven away?
No, I don't.
Why not?
I don't for the reason that I've already mentioned, which is that he spent a whole hour in the front seat without being driven away. Why are they not putting him down in a more comfortable position on the back seat so he can sleep off his dreadful drunken state? As far as he's concerned, why does it follow with respect that must mean he was going to be driven away?
But,
And it also assumes that he knew that he was being put in the back of a car as opposed to just being put on a bench or in a taxi.
Well, but the first part of that sentence is the assumption on which this is all built is that he knew he was being moved from the front of a car to the back of a car, of this car.
Well,
That's what I'm suggesting to you. That's the key point, really. If he knew it, if he didn't know it, then you've got a case. But if he did know it, then isn't the judge entitled to conclude it was only consistent with his consenting to remain while it was driven away?
So your lordship's postulating somebody who's got sufficient compos mentis to comprehend that he's been moved into the back seat of the defendant's car.
Yes.
On that premise.
This car.
Of this car owned by this defendant.
Yes.
I think the problem still is, my lord, I mean, you're getting closer, obviously, in that scenario, but we're still having to face the fact that you have to have regard to his particular condition, which was a desperate desire to go to sleep, as it had been for the previous hour. Why not getting into the back seat, not a desperate desire to continue being allowed to sleep, even though they've decided for their own purposes that they think they would like to move him? Why is it not that he can continue
So
to
my
sleep?
law was focusing on the words only consistent.
It's not only consistent with respect.
Well, I was going to ask you about that. That is undoubtedly what the judge says, and you can criticise that. Suppose, though, he had said most consistent, or the most probable finding is, would that not have been enough from the judge's point of view? He doesn't have to say only consistent.
My lord, he could say that, but he would be ignoring the evidence as to this
Well,
man's state.
quite.
In the
So
process.
your point would still remain,
My
but
point
I'm
still
just wondering
remains.
whether the judge made it unnecessarily hard for himself by putting it that high.
I certainly didn't ask him to do so.
No.
Are you saying at its highest it can only be equally consistent with
Exactly. And therefore it's not an
because
inference.
of the paucity of the evidence?
Therefore it's not an inference you can draw. It's a conjecture you can think. And you can... There were a whole panoply of possibilities in this case that can be conjured up. But where's the evidence? I keep coming back to that. Politician had to say, where's the beef?
Thank you. Well, I'm sure my lord is right. I think this is the key paragraph in the case, subject to our establishing exactly how the law has to be formulated.
Yes.
But it's all about what can safely be found as a matter of inference about his
State of mind.
good phrase, about his state of mind at the time that the move took place. And you say nothing safe can be found, and therefore the burden of proof of proving contrib isn't established. Yeah.
So, my lord, I've continued with that in this table 58. If I just go through it.
I'm not sure this. This really. This just covers the same ground we've helpfully covered question and answer.
Exactly.
Let's just skim through it and just check there's nothing extra there. Yes, on page 9,
Yes, Lord.
that bullet point, that's something I've explored with. The one in the middle between the hole punches is the one that I've explored with you already.
So then we get to the passage, trial judge gave 3/4 reasons.
Yes, the top of page 10.
Yes.
Yes.
Why he found that he's consented. One, if his intention had been to leave the car before it was driven off. So that makes an assumption in itself. He would surely not have got into the back of it. And I'm saying, why would he not get back into the back in order to continue his sleep? And you also, the court also needs to have regard to the fact that he had been passed out when Aaron left him for the second time. So the last evidence the court has of his state before he's manoeuvred into the back seat, and they use a neutral phrase, is that he was passed out. So he has to be roused from that. What state was he in? Was he still stumbling around? Was he still semi-comatose? And how many people helped him into the back seat? 2, C knew that the car belonged to D. Well, again, I'll make a simple point. There's no evidence that he knew he was getting into the defendant's own car. Could have been a taxi, could have been. 3, he, Dean, would be the only one likely to drive. Again, there's no evidence that he knew.
Well, these are all posited on the basis that he's a reasonable, prudent and competent person for these purposes. Then you can follow it, because why are you getting into the back seat of a car and someone going off to get a jump lead so it can be driven? Who's going to drive it? The person who owns it.
Yeah, so there's somebody who hasn't drunk so much that he appreciated what was going on. And the problem in this case is the evidence suggests he didn't know what was going on.
Well, there are really two questions here, aren't there? There's one, exactly where is the dividing line between what's objective and what's subjective, and that we're going to come to it when we come to the law.
Yes.
And then once we've decided where that is, does the evidence suggest that he was on which side of that dividing line? Should the evidence have be taken as showing that he was? We're nearly there, I think, as regards the evidence on the second question, where we've got to come back to the law in a minute.
Indeed.
I'm quite interested by your point 4 on the burden of proof.
Yes.
I mean, the judge quite explicitly at 57 says the burden of proof or the presumption of capacity operates, and therefore the burden is on the claimant to show that he was incapable. And you say that's a reversal of the burden of proof on the defendant to prove contributory negligence.
Yes.
Are the two not possibly reconcilable? That if you show a situation which would normally show want of reasonable care, is the evidential proof not on the claimant to say, well, I know normally it would be want of reasonable care to get into a car with someone I knew had been drinking all evening, but I can show you that I didn't appreciate those facts because of how drunk I was. Is that not okay?
Well, it's slightly more complicated than that. I'm sorry not to give you a direct answer, my lord, straight away, because what if you go to paragraph 45, 4, so that's page
Yes.
89 of page 9 of the we've got, as part of the capacity test, to reach a decision. The information relevant to a decision includes information about the reasonably foreseeable consequences of deciding one way or another, or failing to make a decision. And that's not an issue which, with respect, the trial judge ever addressed in his judgment. So he didn't ask the question, well, did this man appreciate the consequences, in effect, of the decisions that he was making in order to arrive at a decision that he had capacity. Now, quite apart from that, the fact that you found to have the capability of making a decision doesn't mean to say that it's been proved in this particular case that the decision was reached by the claimant. So the burden, ultimate burden, still rests with the defendant to establish the requisite ingredients of the requirement for contributory negligence. Defence is established, so they're not coexistent. They're not same sides of a single coin. The fact that you have the capability doesn't mean to say that you did have, in this case, the foreseeability element, which I respectfully submit is critical to the outcome in this case. Foreseeability of the risk that you are facing, which is said to be the basis upon which blameworthiness on his part can be found. The blameworthiness in itself imposes certain subjective elements as well. And we can see that, if I digress for a moment, in the case of some obvious examples, children, you don't have the same standard.
Yes, well, we're going to come to the law in a moment, but I was just putting to a particular point about the burden of proof. But anyway, thank you. Right.
So
do we need to go through the rest of the... We don't.
No.
We got to the end, haven't we? Yes.
Got to 60. 60, I suppose the point I'm making is the test that is applied is that it was for the claimant to prove that he was incapable of being aware of the amount that the defendant had consumed, even though it had been passed out for an hour. So, I then dealt with capacity. I'm not sure that's taking us very far. We've got, if we go on to, I think it's your page 15 on a slightly different format, another box area.
Yes.
Which is a further analysis of the judgment and the comments are on. And this is the objective test element. So here we come to some law. And the test that the judge applied. So this is grounds 1 to 4.
Sorry, as you say, your pages may not be the same.
Paragraph 60 is a box which starts at paragraph 62. And
Yeah,
paragraph
got it. That's
63
page 14. Right, so that's where we're picking up your speaking note.
Yes.
Yes, thank you.
So We submit that the Ernst and Brummel test is the one which the court should apply, is one which has been approved over a long period of time in a whole series of subsequent cases, but in particular by two Court of Appeal decisions in Brignall and in Booth. And what the Ernst and Brummel test is twofold. The person agrees to go on a pub crawl with the intended driver, he will have accepted the risk and consented to what may then follow. So that's on the basis that when he's sober, he's made an agreement that they'll go out drinking together and Charlie will drive me home. That's Charlie's car. He can't then complain that he got too drunk to appreciate that Charlie was drunk and unfit to drive. Secondly, if you agree to accept a lift from a person who's going to drive you home and you know, so this is actual knowledge, that he has consumed such quantity of alcohol as is likely to affect his ability to drive safely, you'll have accepted the risk. So that's the twofold test laid down in Ernst and Brummel. And that has applied, as I say, since 1976, I think it is when that decision was arrived at. And it's been supported by all the textbooks as being the appropriate test to apply in cases such as this. Booth, of course, the judge referred to the case of Booth and said it was an objective test. Booth, of course, was a pub crawl case, so it fell within the first limb of Ernst and Brummel, and therefore was a pre-arranged agreement. And the fact that he later got drunk and didn't appreciate that the driver was unfit to drive couldn't avail him. 68, say the judge is then applying a purely objective test relying on the decision of Booth. We submit that's not what Booth decided. On the contrary, Booth affirmed the correctness of the test laid down in Ernst and Brummel, which ruled that such self-induced lack of knowledge only warrants contributory negligence, finding when there is that pre-arranged agreement. Perhaps I should take your lordships to Booth.
Before we get to that, can I just ask this question? One analysis of these points on these authorities might be that you're reading them as if they're statutory instruments rather than examples of decided cases in applying law. But the fundamental principle in contributory negligence is that you are dealing with reasonable, prudent and competent person. And if you put that person into the position that Liam was when he moves into the back seat, what is wrong with that as a matter of law? That's the thing I would like help with.
Yes, well, as a matter of law, it's not a purely objective test because it has to take into account the particular features of the individual who's being charged with contributory negligence.
Well, is that
So it's
right?
not a pure objective test.
But that's only true, surely, about children and what we used to call patients. It's not true about drunkenness.
Not true about?
Drunkenness. It might be true of, could I just ask this simply so you can address it? It might be true of external characteristics, your age, your sex, your physical illnesses, etc. But not what you've been doing on the evening.
Well, phobia, for example, I mean, in Froome and Butcher, Lord Denning accepts, or in a later case of Conway, perhaps, is the better one. It's accepted that somebody has a phobia of a seatbelt, for example. That can, although it's not what the reasonable person would do and accept, could be a ground for not finding contributory negligence against that passenger, because that passenger had a phobia.
But my lord, that would be, in my lord's classification, an external characteristic. It would be an illness.
Well,
and how many people have succeeded on that defence? Because the short answer is don't get in a car, walk.
I take the point that you could categorise that as being an external factor. The difference about drink is, if, let's postulate this scenario. Claimant goes out drinking, no intention of getting a lift home, he's going to walk home. He gets hopelessly drunk. as he's coming out, two people get hold of him, take him to a car, put him in a car, and then drive him off. And he is hopelessly drunk at this stage. See, the risk, the foreseeability of risk in that case, or if he's kidnapped and bundled in the back of a car and the driver's drunk and there's an accident.
If he's kidnapped, that's easy because he doesn't not
There's
done
no
a voluntary act.
Yeah. But in this, let me go back to the first scenario then. So he wasn't going to go in the car, he was going to walk home. But in fact, third parties take hold of him and put him in a car and drive him away, and the driver has too much to do.
And that would be
Had he not been drinking, he would have appreciated that he shouldn't get into that.
But you say they put him in, so that's again not a voluntary act.
Yeah, but that's this case.
Well, I wonder whether this isn't a possible analysis. You ask, firstly, whether he has done any voluntary act, and that is essentially comes under the heading of capacity. And if he's so drunk, he can't form any intent to do what he's done. At one extreme, he's just unconscious and he's actually lifted into the back of the car. Obviously, no problem for you. Tricky borderline about just how drunk you are so that you can't make any decision at all, even if you can move a bit. But once it's a voluntary act, then you are judged by the standards of a reasonable person doing that act. And the fact that a reasonable person, a non-drunk person, wouldn't have done that act, by putting it another way, the test simply then is whether a sober person would have done that act. So the first is it a voluntary act, which is a question of capacity. After that, drunkenness is irrelevant. If drunkenness is not so extreme as to deprive you of capacity, it becomes irrelevant. Is that a way of analysing it?
Well, it's one way of analysing, but
Is
it
it
puts
a right
it too high.
Is it the correct way?
With respect, it puts it too high because on that scenario, your lordship's postulating the fact that the person is literally incapable of moving.
Well, I didn't say capable of moving. I meant incapable of. It's quite a fine way of formulating it, and it might help you. But still, we all recognise the concept of capacity, which is whether you're capable of taking a voluntary decision.
Yes.
And I'm saying that's the test. And at that point, drunkenness may be relevant to that if the drunkenness is of such an extreme nature. But once that, if you don't show that you were incapable, you are then judged by the standard of a sober person.
Well, it depends. Depends what we mean by incapable. In that
Well, I
sense.
agree.
And what I'm venturing to suggest in this case is that this man left his own devices, wouldn't have gone anywhere near the car. Right? He was being taken out by the bouncers, and so everything that happened to him thereafter was somebody else's decision. It wasn't his, and he was so drunk at that stage that the moment he's put in the car, he passes out. Right? And he remains passed out for an hour. They come back, they get into the car, the back of the car, Aaron does. He's pulling the seat forward, he's getting into the back seat, he's getting out again. This man is still passed out, and he is passed out when Aaron departs to get the junk leads. Now, that is a man who's not making voluntary decisions in relation to his position in the car. And the same applies when he's moved into the back seat in our respective position. Bearing in mind, there's no evidence as to his state when he's taken out of the front seat, because it's not his decision, and put into the back seat, which is not his decision. That's the findings of the judge. And he is, on the last evidence, we've got a man who has passed out. So he's, in order to make him move, presumably, he's been roused to some level, but that's not to say that he has any conscious awareness of what he's doing or what's being done to him, still less why it's being done to him. That is not a voluntary act in our respectful sense.
Yeah. No. But I think you're accepting my analysis, but saying that the test of capacity isn't simply unconsciousness.
That is right.
It's a more it's a lower hurdle. Yeah, higher, depending which way you look at it.
My Lord, I
Thank
think
you. That gives me a way to look at it.
well, so can I take you to the case that most clearly articulates this
Yes.
issue? So it's the case of Macpherson, the Australian case. For some reason, the Australians seem to have faced this problem more regularly than we have.
We're being live streamed, so it's probably not appropriate to comment.
Just happened to be the case.
Which divider is this?
This is divider 24 in
Thank you.
second bundle number. So there's the Court of Appeal, Queensland, Chief Justice McCrossan. Although the plaintiff was called Macpherson, there was also Judge of Appeal Macpherson and Mr. Justice Lee giving the judgments. Mr. Justice Macpherson agreed with both.
Just before you start, please do go to this case, but this is prior to the decision of the High Court of Australia in Joslin, which is both later and obviously more authoritative. I'm not saying there's anything different. I just want to understand. That's right.
That is correct, Lord.
Okay.
And when I take you to the decision of Mr. Justice Kirby, the famed Mr. Justice Kirby, in Joslin, you will see that effectively in Joslin that it's a statutory interpretation case on their statute.
No problem. I just wanted
and he
to.
He doesn't disagree with this decision.
Okay.
That's
Let's go through it.
So the postulate, I think I just take you to page 404 of the bundle. Modern considerations of such issues usually start with Joyce. There's also the case of Morton. No need in the present case to examine the correctness of all the pronouncements of Cooper J. and Morton and Knight. He was a purely objective test man. But it may be noted that some questioning of that decision, as well as further full examination of the authorities, to be found in an article by Professor Hogg. The following limited observations are sufficient in this case. Test involved in assessing the extent of the failure to take reasonable care for one's own safety, which is what the issue in contributory negligence is concerned with, invites attention to the level of care which can be expected of the reasonable man in the circumstances as they present themselves. If a person should reasonably foresee that he may subsequently be confronted, man should reasonably foresee that he may subsequently be confronted by the necessity to choose whether or not he will travel as a passenger in a car by an intoxicated driver, but nevertheless imprudently proceeds to drink to excess, diminishing his capacity to discriminate, reducing his ability to make a reasonably careful decision. When the occasion does arise, the man will not escape the finding of contributory negligence. The test which will apply in these circumstances will regard the behaviour to be expected of a reasonable man with the risk of a future eventuality to be confronted should have been reasonably apparent. This is a different situation from that in which a person will be placed, where he allows himself to become intoxicated in circumstances where no reasonably foreseeable specific risk to his safety should have been apparent to him. If in these circumstances, whilst lacking relevant conscious awareness, he is placed into or induced to enter into the car of an intoxicated driver, he should not on that account be held responsible for a failure to take reasonable
So that's
care.
postulating a case where he has no relevant conscious awareness, in the language I was putting to you, where he has no capacity. Is that right?
Well, lacking the relevant conscious awareness that he's being placed into or induced to enter the car of an intoxicated driver. That's the test that he's applying. So that's not total incapacity, that's an appreciation of the risk that's being faced. So there's a level of awareness.
And does the judge deal with the fact that it's an objective test for contrib?
Well, if we go on to what he says, no, he just then deals with the I mean, this case was if I remember rightly, this was an Owens and Brumman prearranged drinking spirit case.
Yes.
So this is why.
So this is over.
Yes.
Yeah, no, I'm just trying to find out. I'm not trying to trip you up. I'm just making sure that my note is accurate.
Route is accurate.
Yeah. And there was an 80-20 split in this case anyway, because he found on the facts that he should have known. Yeah. Yep.
Macpherson on page 406 agrees with both judgments. We go to the judgment of Mr. Justice Lee and Len Ward. And he deals with Valenti, which we don't need to trouble ourselves with, until we get to contributory negligence on page 14 of the judgment, 412 of the bundle. It's of fundamental importance to note at the outset of any discussion.
It's quite a long passage. How much of us would you want us to read all of it?
Well,
It'll be quicker than
yes,
if we
I think if you
Why don't we read the
up to the top of 16,
the box
or
bit?
16,
Yeah, we'll read-
I'll pick it up at the lower half.
Okay,
16
that's
and
fine.
17.
Give us a moment then. Yes, I think we have. Yeah.
Oh, is this discussion entirely obiter as well?
Yes.
Well, it's inevitably so, isn't it?
Yeah.
None the worse for that.
No, very interesting. It talks about the external characteristics as well.
It talks about the subjective elements as
Yep.
well, my lord, as you will see in page 14.
Do you want us to read the
Yes.
second box?
Well, the second part is the critical bit. So
Okay,
I'm
well,
conscious of the fact that this conclusion may be seen by some as running contrary to the comments in O'Shea, but of course that was the case that had engaged in a joint bout of drinking before the use of the vehicle, quite distinguishable from the situation which arose in Morton and Knight. I'm conscious of a view which has been expressed by some that it would be unfortunate if the law were to reach the result that a drunken passenger to recover more than a sober one in similar circumstances. The trial judge's point. With respect to those who might hold that view, I would add equally, I can see no social policy to be promoted by a rule the effect of which would be to compel a plaintiff to remain sober to independently assess a driver's condition, when at all times during which his capacity to do so existed, no foreseeable risk of injury to himself arose. The issue as I see it is not whether the law should allow self-induced intoxication to be used as an excuse of some kind, but rather whether the law should require a plaintiff to take precautions against a risk, which at the time when the choice is to be made, whether or not to take those precautions, is not foreseeable. Clearly, so far as the latter proposition is concerned, if accepted, would lay down a requirement that's contrary to all principle. In my opinion, Morton is not good So there we are. We have a clear articulation of the foresight rule and the fact that the person to be found contributory negligence an appreciation of the likelihood that they were going to be conveyed away whilst they were in a position to make that judgment. But if that prospect of being placed in the car and driven away arises after the individual has got hopelessly drunk, as in this case, then the situation is different because the foreseeability of the risk that came to pass only arose when that individual was not in a position to make a sound judgment on that issue. Now, Your Lordship referred to the later case of Jocelyn. I just try and make these points in the judgment of Mr. Justice Kirby.
And now, which tab are we on now?
It's the next tab.
Tab 30, yeah.
25.
Just help me, which is the majority judgment?
It's always a difficult question with these long judgments in the Australian High Court. I'm not sure that there were differences of view as to how their statute should be interpreted. So it's a statutory interpretation case.
No, I just wonder why you would take this, Mr. Justice Kirby. If Mr. Justice Kirby's was the lead judgment, then fine. But I had rather assumed, without having done a careful analysis of it, that the leading judgment was that of Mr. Justice McHugh. But I can see actually Justice Kirby's is much longer, so that's not always the test. But I mean, how does it actually work? There were 5 members of the court. The first judgment is that of Mr. Justice McHugh, which goes to page 438 of the bundle. Then we've got a joint judgment from Mr. Justice Gummo and Mr. Justice Callanan. None of them say they're agreeing with they don't follow that convention. That finishes at.
I think Mr. Kennedy's got a.
I don't know whether my learned friend would share this analysis. But my analysis of the judgments is that McHugh deals with contributory negligence of common law, and the other judges deal with the Act. He deals with the Act as well, but the only one who deals squarely with common law is McHugh.
No, I can't agree with that. But
Well, it doesn't matter. Okay, that's just helpful to have that in mind.
Yes.
Anyway, I think at some point you better deal with what Mr. Justice McHugh says, which certainly to me seemed to be against you, but and to disapprove McPherson. But that's why I was quite interested to know what, as it were, the relationship between the different judgments was. But you take us to what you feel you need to.
459.
Yeah.
I'll be quite brief in relation to this. Paragraph 144. We've been dealing with the case of Saunders. Regarded as critical to ascertain whether the evidence established the passenger knew that it was likely that he would be a passenger to the driver. Your Honour's reasoning that in rejecting contributory negligence treated as determined to the onus resting on the defendant to establish the defence, and the need for the defendant to prove that the journey with an intoxicated driver was reasonably foreseeable before the passenger became incapable of deciding whether or not to so proceed. Then he indicates the 2 emerging approaches.
Yes, I see. Sorry, that was 114 you were reading from.
That was 114.
Yeah, thank you.
And then 115, 2 emerging approaches. So he's saying this. On the one hand, 116, there's Morton. 117. On the other hand, there are cases which focus more particularly on the conduct immediately preceding the accident. They consider including reference to the passenger's own state of sobriety, capacity and depreciation, whether he or she was then, and could with reasonable foreseeability have anticipated being in a position to decline the profit opportunity to travel in a vehicle driven by an intoxicated driver. The illustrations of this approach include Banovich, Saunders and Macpherson, which I've just taken your lordships to. And then he leaves it there, saying there are those two strands of approach in the Australian cases. And then he goes on to the statutory provisions issue. This is at page 462. And you can see that his decision thereafter is then concerned with
Australian statutes.
Australian statutes.
Do we have where do we find the statutory provision with which he was concerned?
Section 74.
Sorry, section. Where do we find it? Sorry, where's it set out?
If you go to 131, the end of 131, which is on page 466, the Motor Accidents Act,
Oh, thank you.
shall be made in the following.
Yes, thank you. Very helpful.
So, and if you're looking for the purpose of the Australian Act, your Lordship would go to 138 on page 468. Clear purpose was to address
Sorry, which paragraph are we on?
138 and what follows thereafter.
What was the date of the Act?
1988. So, what I say about this case, Jocelyn, is that it's a statutory interpretation case. And where's the state of the law in relation to the common law? Well, it's, as Mr. Justice Campbell was indicating, there are two strands of thought in relation to the position.
Well, hang on 1 second. I mean, in one sense, you might say the 1945 Act is statutory. The fact that statutory interpretation doesn't necessarily mean that the effect of the New South Wales statute is any different from the common law. It may be, but I'm just saying.
Yeah, Your Lordship, that's obviously a correct point.
And what Mr. Justice Kirby said in this case was show deference to the trial court, because otherwise you create problems, and there are two strands, and I'm not going to reconcile them, and they can sort it out at trial. Because that's what they do. They send it. They remit the whole case back, don't they?
They did.
But where does Mr. Justice McHugh's statement then stand, where he says plainly that he prefers the objective test?
There's one view amongst the five of them. That's where one ends up. It wasn't critical to the outcome of that case, and so it's overturned.
So it is overturned, and Mr. Justice Kirby just marks the two, and then says leave it up to the trial judges.
So how is that helping us with the interpretation of the law here?
Well, I'm not saying it's binding on you. I'm saying that what that case of Macpherson does, which is not disapproved of in Jocelyn, that's the only point I was making.
Well, it is. It's disapproved of by Mr. Justice McHugh.
And I thought we agreed that Macpherson comments were overturned. So there's a disagreement amongst the higher court in Australia, the High Court in Australia, about overturn comments by the lower court. How does that help us?
Well, it helps you because it's a very, one of the few cases that directly addresses the factual problem that arises in this case. That's why I've taken you to it. Because
Yes.
we've got here somebody who gets hopelessly drunk before the risk that eventuated was ever likely to happen. And he is hopelessly drunk when the risk about which the defendant complains, namely allowing himself to be in a car driven by that stage, he is hopelessly drunk. And therefore, that goes to the question, contributory, goes to the question of blameworthiness, and therefore that is why it's not a purely objective test.
Do you want to say anything? Sorry.
Yes, my lord.
No. Do you want to say anything about paragraphs 36 and 38 to 39 in Mr. Justice McHugh's judgment? Because he, unlike Mr. Justice Kirby, did express a view on this, and he said Macpherson was wrong. And he is a judge of the High Court of Australia. I assume you're going to say he's wrong, but I just wondered if you want to point to any flaws in his
Apart
reasoning.
from that, my lord, no, my lord, you have his view in relation to it, and there's
Okay, that's fine.
there's this difference of opinion in the Australian courts. We respectfully submit that that issue arises directly in this case, and therefore that is what the lordships will now have to decide in this case. And so I've endeavoured to articulate.
And are we safe to assume that I've just had a skim read Mr. Justice Hayne and Mr. Justice Gummer and Mr. Justice Kalina? I don't think they really take matters any further, do they? I'm not asking you to take us through. I just want to check we're not missing anything in
Now, if that's right, it's quite revealing, isn't it? They didn't feel the need to express an opinion, despite the divergence of view by two of their colleagues. Doesn't this all rather undermine, with respect to the Australian judges, the weight which can be attached to their expressions of opinion, one way or the other? In this case, and in Macpherson. In fact, all that this case does, it might be said, is to undermine any reliability that can be placed on what was said by the judges obiter in Macpherson.
Well, there's not a majority saying that it was erroneous.
Well, it doesn't really matter. I mean, none of this is binding on us.
Exactly.
What you have shown is that there is one body in Australia by eminent judges, the Court of Appeal of Queensland, and they are themselves following other state courts. But there is another view, not just Mr. Justice McHugh, but a line of cases that he identifies, including the case of Morton,
Correct.
which he approves and which was disapproved in Macpherson. So there's just a difference of opinion.
There is a difference.
And it's of no value to us, except insofar as we find the reasoning particularly persuasive. There we are.
That is it. That's the reason I was taking you to it, because we respectfully submit that the reasoning, bearing in mind that Macpherson, the Chief Justice Macpherson and Mr. Justice Lee in Macpherson directly address a set of facts which are analogous to ours, that their judgment is helpful, because they're acknowledging that distinction.
Can I just ask you then, if it is for us, so far as I'm aware, the orthodoxy in English law is that this is an objective test, and then subject to external characteristics such as age, sex, etc. And in those circumstances, what the judge did would have been perfectly permissible if it was an objective test. If you took the reasonable, prudent and competent person and put him in Liam's specific position.
Well, I respectfully submit that in relation to the objective test itself, and I think if we go back to Owens and Brimmel, we see why. Mr. Justice Tasker-Watkins described it in the way that he did was because he appreciated that there are two separate likely scenarios that are going to arise. And the tests that he applied in relation to that were not purely objective, but secondly, he articulated as regards the person who then later becomes too drunk to make a sensible assessment, is in there against a set of facts where that individual has reached a prior agreement with the driver that they're going to drive. So at that stage they're sober, at that stage they're able to make a judgment call in relation to a decision that later becomes difficult because of the amount of drink that they've consumed, and they make a decision which otherwise perhaps they wouldn't have done, or certainly one that they shouldn't have done. Whereas here, the occasion of the prospect of a drive away arises so late in the developing facts of the case that the individual by that stage has lost the ability to make a sensible decision, has got himself into that position without reference to the risk that came to pass later.
Can I just ask you one other point, simply because if one's looking more generally at these cases, once you drink to that level of excess, I mean, you were suggesting the bouncers should have, looked after him. We all know their interest is getting the person out of the club. We also know that taxis cease to become a viable option when you've drunk to that excess because they're obviously worried about accidents in their car, and you put yourselves in the hands of those that you trust to look after you, namely your friends.
Well, but does that mean to say that you should have foresight that, of everything that your friends decide to do thereafter in relation to you? That's, with respect, the reason why the timing of the state you get into whereby you're not able to make the sensible judgment that you would have done if you were sober is so critical. Your Lordship postulates what was likely to happen to this man. The most likely, I venture to suggest, the most likely outcome in this case is the bouncers, of course, accept your Lordship's point, they would have wanted him out of the club, but they all know that they have a duty of care to these people as well. The most likely outcome would have been, given this man's state, was that they would have called up an ambulance to take him for an examination at the A&E department. So to say, oh, well, he was going to be in the hands of his friends who would then decide what was going to be done with him, that cuts right across the blameworthy criteria that is an essential ingredient in the decision to make a finding of contributory negligence against a particular individual.
Thank you.
You said that Mr. Justice Tasker-Watkins in Owens and Brimmel effectively, the principle you're relying on is based on that. What precisely is it in what Mr. Justice Watkins said in that case that you rely on this point?
Well, I've put it in my.
Okay, well, it's in your speaking note.
It's in my skeleton as well.
Okay.
Let's look at the case itself.
Well, if you just get a skeleton and show me where it is in your. Page 866H, is it?
It's at the bottom of page 26 of the core bundle.
Yeah.
Sorry,
Wrong page.
that's the wrong one.
24, top of 24.
It's page 24, paragraph 23.
Yeah, and that passage is 866 in the report, which is at 336. So this is the last passage, paragraph from that page.
866H to 867C.
And what about the discussion of Slater and Clay, which was obviously when the Contributory Negligence Act was new,
Yes.
wasn't pleaded, and they were all saying plead it
Yes.
because inferentially it would have been applicable.
Yes.
I mean, that would be inconsistent with this being authority for the proposition you advance.
Yes, so he's done the review of the American Law Institutional Restatement. He's done the Canadian authorities. At C on page 866 of the judgment, 336 of the bundle.
You talked about Slater and Clay a bit earlier in a passage you haven't boxed.
The point that I've been seeking to make at C on page 866 said it can be affirmed that she was negligent where the risk in question, that her negligence in that regard contributed to her loss when that risk eventually was the conduct of the road. Deals with the Australian cases up to that point.
So sorry, where are we looking at?
We were looking at 336 of the bundle, authorities bundle.
Yeah, thank you. Keep going. Yep.
2. That's the case of Owens and Boom.
Yes.
At 867B to C, sorry to just ask you this specific point.
Let me get to it, my lord. 867
B to C.
B to C.
I mean, whatever he'd said about the test, where he puts it here, they were both reasonably intelligent young men. Plaintiff in particular must have appreciated at some part of the evening, in my view, that continue the bout of drinking would be to expose himself to the risk of being driven later by someone who would be so much under the influence of drink as to be incapable of driving safely. I mean,
Yes,
that's a much lower test than express knowledge at the final instance.
Well, it's in the context, isn't it, my lord, of a pre-arranged agreement that they would go out drinking and that the defendant would be the driver. That's the point. So the judge is saying in those circumstances, when you were sober, you agreed to go out drinking with this man, so you were reckless as to the outcome. You've got to live with the consequences.
Well, no, in fact, because the judge actually says that it was far more likely that the two of them were bent on a kind of what is known as a pub crawl and gave really little thought to what happened later and were recklessly indifferent to it.
With respect, my lord, yes, he does say that, but that's in the context of them having pre-agreed it. He does say that. Let me find the passage. Got one more point that I need to deal with before we break. At C, I think it more likely, however, that the two of them were bent on a kind of what's known as a pub crawl and gave little, if any, thought to the possible consequences or were recklessly indifferent to what they would be. That is to say, when they set out on their pub crawl, they were recklessly indifferent as to what the outcome would be. So that's why they're being judged as being culpable. Because they made a decision when they're sober.
Assuming for these purposes that this is a complete and accurate statement of the law and it goes no further than that, then how would that apply to this particular case where the three are drinking 3 bottles of champagne, 20 shots, brandy and coke?
Because there's no, in this scenario, there's no contemplation that he is going to be taken home by these people.
What about reckless indifference, which is how Mr. Justice Watkins puts it?
No, but because he said, forgive me, he has said in this case that they made a prior agreement.
Can you just take us to that bit? I'm sure you're right. You're right that he posits that as one of the ways in which liability can be put.
That's right.
But his finding of fact about where they made the prior agreement, I haven't found yet.
Well, look at the head note, my lord. That's probably the quickest place I'm going to find it. At 3:30, my lord. If either he knew that the driver had consumed alcohol in such quantities likely to impair to dangerous degrees.
Well, that's setting out
that's
the
actual
test.
knowledge, or
Yeah.
knowing that he would be given a lift in the car accompanied the driver about a drinking, which he'd effectively eventually of affecting the passenger's clear thought and diminished his capacity to drive here. And so he's contemplating there, in this case, that they had a prearranged agreement. And if we go to the bottom of H on 336,
Yep.
he knows, if he rides with the driver who he knows has consumed, also be a passenger if he, knowing that he is going to be driven in the car later by his companion, accompanies him on a bout of drinking. So that's the pre-agreement.
But the actual findings in the case appear to be 867B onwards.
Yeah, but yes, that may be so, my lord, but at C, the passage that you've referred to at C is in the context of them going on a pub crawl, having arranged in advance.
Well, you keep saying that, but like my lord, I haven't found where there's a finding to that effect. I've just been looking again at the findings of fact, which appear to be at pages in the judgment 861 to 862. All that I can identify is that the plaintiff couldn't drive, so if they were going to go back in the car at all, it would be the defendant driving them.
Well, just above G on 867, page 337 of the bundle, I think it's a clear case. Either on the basis that the minds of the plaintiff and the defendant behaving recklessly, or equally befuddled by drink, so as to rid them of clear thought and perception. But that's against the earlier finding that he's made.
Yeah, but you keep saying that.
deciding
Where
on-
is the earlier finding? Straight question.
C, paragraph C.
Of 867.
Well, that's my lord's point. That doesn't depend on there being a pre-arrangement.
It's just, you're going out, you're not driving because you've drunk to a state of insensitivity, and you're then dependent on those who you're drinking with, one of whom might be able to take you home.
Well, it's right that if you are in the pub drinking with another person, and at the end of the day you decide to make a decision to go back with that individual, there are a whole host of scenarios. You made a foolish decision which you wouldn't have made when
You speak up.
You're making a decision which you wouldn't have made had you not taken drink. Except in that scenario, you're going to be judged by what other people, the evidence from the other people that's going to be given in the court, which says, well, this person was clearly not fit to drive, and so you're now, in that scenario, going to be found to have made a decision which you shouldn't have made. You've made a voluntary decision when you're with that individual to drink to excess. You're going to be judged accordingly. But that's, I'm repeating myself when I say that's not the scenario, because we've got the risk arising at a very late stage. And to say that you can't go out drinking other than on a basis that whatever third parties decide to do to you thereafter, you're going to be found guilty of contributory negligence if they happen to put you in a car and the driver happens to be one who shouldn't have been driving. Now, I've got a final point in the appeal, which is of great importance.
Okay, well, just before we come to that, while we're on the authorities, I think you have said generally that the textbooks are on your side, and I don't think Mr. Kennedy would agree with that. But I've just been looking at the passages we've got in the bundle. I won't go through them all, speaking for myself, but obviously not rely on any of the others. They don't really seem to address this point. With the exception of Charlesworth and Percy, which says at 4, this is behind tab 27. First of all, it says it's no excuse for failing to take reasonable care that the person in question was unable to take proper care as a result of voluntary intoxication, and that gives this decision in first instance as authority for that. At the end of the passage that's been sidelined, it says, likewise, a passenger in a car so intoxicated as to be unable to perceive the driver was unfit to drive through drink was guilty of contributory negligence when a collision occurred. The reference is given for that at Owens and Brimmel. Well, we've looked at that. Obviously room for debate about exactly what that does decide. That's what the editor thinks it decides. But see further, paras 4, 136 or 137. We haven't got those. I don't know whether they're relevant or not, but I wonder whether someone could look over lunch and see if they are. And then also an article in the Journal of Personal Injury Law. I have no idea whether that's likely to help us or not.
Not going to help you either.
You've looked?
Yes, it's a practitioner's view.
Yep, okay. Thank you.
Lord, I accept.
Practitioners' viewpoints are very helpful.
Sometimes they are, Lord.
Well, if you have looked at it, I think and you therefore have got it, I think for completeness, could we have a copy of that? One or...
I accept that...
Well, you said it wasn't to help us, so you've obviously looked at it.
Yes.
So, okay, I don't mind who... Either side can look at it. We don't know who it helps, but I wouldn't mind seeing it if
yes,
it's not difficult. Yep, okay, thank you. Right, sorry, you had the point you wanted to go to.
Well, it's the apportionment point.
Yes.
But I take you then back to my speaking note.
Now, let's just say about timing. My lord has an important engagement over the shorter German. We probably can't sit again until 2:10, and we'll also have to rise promptly at 1,
if possible.
Promptly at 1. It's perfectly appropriate for the person opening, who's had to take us through more of the detail, to go marginally into the afternoon. So we will allow you to go marginally into the afternoon, but you haven't got to gabble it all out by 1 o'clock. That wouldn't be fair. But I think you'll have to be pretty succinct.
Well, my lord, can I make a start on it?
Yes, of course. No, please do.
So, my lord, if you go to another tabulated section on the skeleton.
Do you mean the turn or the speaking?
The speaking note.
Yeah.
Paragraph.
It's a tabulated thing under subheading contributory negligence apportionment judgment 148-157.
Which page are you speaking of?
16.
Thank you.
Oh, yes. Thank you.
So, the judgment, Owens and Brummel pub crawl case, we say assessed at 20%. That's not this case, and that's why we submit. It ought to be lower because in a pub crawl case, when you're going out with the defendant who's going to be the assigned driver, then you know what the consequences are going to be, and you're going to live with those consequences. And there will be a finding contributory negligence. The difference as to why it's 20%, of course, is the causative element of the responsibility for actually causing the accident. the defendant. The judge distinguished the case of Creamer, which Miller and Friend tried to persuade him to increase the level above 20%. The facts of that case concerned a deliberate driving expedition with the defendant as a driver. That was a 25% deduction. The trial judge came to the same conclusion in relation to the case of Stinton. The trial judge there, then Mr. Justice Simon Brown, said the conduct of the passenger involved blameworthiness to the greatest extent possible short of direct participation in the driving. That there was a question of buying a new car. He was with his brother when he bought the new car. And both knew it was uninsured and went out on a drinking spree. And that's why, and it was MIB case. That's why the judge found 25% contribution negligence in that case. Here, the judge has rightly concluded no earlier agreement between the parties at 155 has found helpful findings for us.
Will you pause a moment? Still competing against helicopter and something else. Thank you.
So the points the trial judge makes, which we adopt, are that the claimant cannot have known how much more the defendant had drunk after.
In a sense, this isn't the disputed area. You're not challenging his decision that this is less serious than the other cases. You're saying he should have said it was less serious.
Correct.
Or more less serious.
Correct.
So really your challenge is to paragraph 157, isn't it? I'm just wondering why you're taking us through the previous ones.
Well, no, if you're just trying to set the background for what he did find. So, yeah. So we're saying there's no analysis. It should be noted in the case of St George, which your lordships have, there's a 0% finding of contributory negligence had that been necessary. That was the then Lord Justice Dyson. Duty on the defendant to take a special care for a vulnerable claimant who one knew as the statement could not make sense for safety reasons. A case of Griffiths, which is in the court's bundle, postulates the possibility of the existence of duty of care on the part of the driver to his passenger if that passenger was plainly reached a state of intoxication and was clearly incapable of taking care of his own safety. Whether or not that duty exists is highly material to the question of contributory negligence and apportionment should be made. And the case of Froome, the seatbelt point, we respectfully submit the court has given some helpful guidance there as to the proportions that for deduction that should be made, bearing in mind that a similar case to this in that the driver has the primary responsibility for the fact that the accident took place and shouldn't have allowed that to happen. And when the injuries were going to be reduced on a seatbelt point, the guidance from the Court of Appeal is that it should then be a deduction of 15%. And so we say on the facts of this case, bearing in mind their uniqueness and their unusual features, and the lateness of the hour at which the decision was taken to put this man in the car who was helpless and unable to make those decisions for himself, the deduction in this case really should have been less than it was in an Owens and Brummel case, which was a case where the parties had set out to have a drinking spree and to be taken home, and to be taken home by the driver. So the distinction with Owens and Brummel is, in Owens and Brummel, the two of them have gone out together, only one of whom is going to be a driver, and the clear indication was that the driver was...
So you're letting your voice drop again.
The driver was starting the evening, taking them there, and the driver in Brummel, Owens and Brummel, was going to take them back because there's only one car. It's not the scenario here. So in our respectful submission, this is an instance where if those factors are taken into account, bearing in mind the trial judge in his judgment he did set out various features as I was taking your lordship to them, which were in 155 of his judgment, but he didn't then articulate an underlying reason as to why he was alighting upon 20% as being an appropriate case. Bearing in mind the distinguishing features between this case and Owens and Brummel, we respectfully submit it should be reduced, and it should be reduced by this court because the judge is in error in that respect.
Well, I note the time, but I'm about. You can take a bouquet if you like for your extremely well-timed advocacy, because that's a very natural place to stop. Do you think? Speaking for myself, I have a very good understanding of your submissions as a result of the interchanges between us. So thank you very much. And I wouldn't have thought you do need to take advantage of the little time I said you could have this afternoon, but how do you see it?
Well, my lord, I had agreed with my learned friend that he would start at 2 before we
Well,
started.
I don't think you will lose anything by sticking to that, except it will now be 2:10. Thank you very much for your help.
Thank you.
All rise.
Email it to you. Yeah. I will see that to the NLR article as well. Just in case they say see that. Do you want to